The other day, I had the opportunity to talk with estate planning and elder law attorney Jeff Bellomo about how investors can structure their investing portfolio to not only protect the assets and the business itself from creditors, but how they can structure their portfolio so it's protected when an elder care or assisted living is needed. And then the income stream can be passed on to heirs when the time comes. Jeff shared so much valuable information that I had to break the interview into two parts. Here's part two.
You take the bubble, it's protected from the inside out. You put it into the wagon. Now it's protected from the outside in because the creditor can't get into the wagon. Now, like any good lawyer, you got to throw that wonderful disclaimer out there that says, every case is different. Every fact pattern is different. Please go speak to, your attorney and get advice for your specific case. The video here today is not constituting attorney-client privilege, and we're not building a relationship. But the point is, go to somebody who's knowledgeable in the area, not only of real estate, but what is the biggest risk to our portfolios or to our wealth? Long-term care costs. I don't think that there is anyone who's going to argue against that. You're looking at $14,000 a month on average in the state of Pennsylvania for long-term care. And what we find happen in our elder law practice on a regular basis is the husband or the wife is the caregiver, right? One of them has dementia, one of them has Parkinson's, the other one is the caregiver. Well, guess who ends up needing to go into the nursing home first? The caregiver. The caregiver, because they're under so much stress, because they've got so much on them. Well, if the caregiver needs long-term care, now both of them do. Well, multiply 14,000 a month by 2, and let's call it 30 grand. Well, you're spending 30 grand a month out of pocket every month. It can go through significant wealth in no time at all. And if your wealth is in real estate, right, what do you have to do now? You might have to start selling off your properties. And to somebody who's trying to pass on wealth to future generations and set their future kids up with income streams, that's like the last thing that we want to have happen, is to be in a situation where, we end up having to sell off property. And I'm not licensed to sell insurance, so this is not, a plug for me in any way, but there is long-term care insurance, sure. But what's the problem with long-term care insurance? It's really expensive. And all the people who have it are now getting letters that say, hey, your benefit is being cut in half. Oh, but your premium is being doubled. So they're trying to fix that. I think that they're coming out with ways to try to combat that. But the problem is that they made a lot of bad bets to begin with, and now they're trying to make up for that. They're trying to cover their losses. That's why there are so few companies in the market anymore for long-term care. And yes, I do want to say this on the record. I actually do like them. And the reason I like the long-term care policies is because they'll keep you in your home, right? A lot of the asset protection stuff that we're talking about is protecting assets from the nursing home. These long-term care policies will actually have riders on them that will keep you in your home longer. So believe it or not, I do believe in them. The problem is not a lot of people can afford them. So it's this yin and yang. And I do think you should talk to your financial professional about long-term care and whether it makes sense. But that doesn't negate or supersede the need for the asset protection trust, because again, the long-term care can keep you home. It can keep you in the assisted living facility. But what we want to stop against is that catastrophic loss to the nursing home or to the long-term care situation. And that's where the trust comes in.
And then for the investor that's building up the portfolio of income producing properties, once they do pass, then that income can be directed towards their kids or to a charity or whatever organization or person that they deem responsible.
Absolutely. And obviously there are different tax consequences. If you're passing to a child in the state of Pennsylvania, it's a 4.5% inheritance rate. If you're passing to siblings, it's 12%. Anyone else in the world, including those lovely nieces and nephews, that's 15%. Charities would be 0. So yeah, every one of them has an inheritance tax kind of consequence to it, but you can transfer it in trust for my benefit and allow it to be asset protected from my divorce, my nursing home, my car accident, and not have it subject to those creditors, but still have the ability to get the benefit of potentially an income stream or the ability for the trustee to pay out or give me money if I need it for whatever purposes that you deem are appropriate.
I was just thinking that, if I own 5 properties that are throwing off income and I've got a halfway decent trustee that's managing that portfolio, the property itself doesn't transfer ownership. So wouldn't be any inheritance, right?
Well, no, it would have to end up, you're going to end up transferring it to the trust for my benefit at my rate, at whatever my rate is. You can't just leave it in the trust. When you die, it's attached to your soc. Now we're essentially going to create a wagon for me, for your son, right? So that's why the inheritance tax would apply in that situation, even though it's in trust for my benefit, but it's still protected. It's still protected from my divorce, my nursing home. And you touched on something that I smiled. A lot of attorneys will do things like, well, we're going to set up the document so that the son, Jeff, gets all of the income from the rentals, or Jeff will get a third at 25, a third at 30, or a third at 35, or Jeff will get guaranteed income of $3,000 a month. I'm making up fact patterns here. But the problem with doing that is, remember debtor-creditor law. Whatever you have direct access to, so too does your creditor. So if the 4 corners of the document or the trust says Jeff has guaranteed income of all rental, or a third, or $3,000 a month, if I end up in a divorce or end up in a nursing home, do I have an outright entitlement to that money? Sure. So who else does? My divorce, my nursing home, my car accident. So we never draft documents to provide for outright distributions. The way that we draft it is, we're going to put the money in trust for the benefit of Jeffrey, with somebody else as the trustee distributing the money to the son, Jeffrey, at the sole and absolute discretion of the trustee. Now, there may be communications between the grantor and the trustee. There may be emails, there may be outside, but we're never going to put it in the trust document. We're never going to put those limitations in there. We're going to allow the trustee to make those choices so that it's fully asset protected.
Well, and that brings up a point, because I was thinking about this last night, is who do I put as a trustee that's going to manage the trust or who's going to manage my portfolios after I pass? I mean, because first of all, I got a complaint with, why does Jeff get all of the benefits of my trust? I got a problem. As much as I love you, I'm not so sure I was thinking about my kids, not.
Yeah. Of course. I was your kid in that example.
Yeah, you're young enough compared to my age. Yeah, or I'm that old. But anyway, so I mean, I guess a great amount of care has got to be put into who's going to be the long-term trustee of that trust, so that it at least that entity organization, the trustee, survives me and shares my goal towards maximizing my real estate portfolio for income.
Yeah, and there will be provisions in the document so that we can figure that out if something were to happen to the trustee that you pick. So we'll have something called a trust protector. The trust protector is oftentimes the law firm that creates the documents. We're not in a fiduciary capacity. It's a non-fiduciary role. But if your trustee dies and you didn't name a backup, somebody has to name someone. Somebody has to be able to appoint someone else to act as trustee, to step in for your family, to ensure that that continues along. But back to your example, if your kids are going to be the ones receiving it with a trustee as the person distributing the money out, when they're under 18, you might have one idea of how you want that money to be distributed. Then when they're 18 to maybe 30, you might have a different idea of how you want that money distributed. And then when they're over 30 or over 40 or over 50, my point is, it's going to change along that continuum as to, what you want to pay out and what you want the money to be there for. So if I'm 50 years old and I'm responsible, you may actually allow me to be a co-trustee of my own money. You may say, hey, you know what, Jeff, you've earned that right. You've earned the right to manage the money. You've earned the right to make decisions as to the real estate and the investments and how you're going to invest it. But again, remember, debtor creditor law says that I can't alone reach in and give the money to myself, because if I do, so can my creditors. So I have a co-trustee with me. Now, you may choose that co-trustee. Maybe you allow me to pick who that co-trustee is. So we're going to treat minors, middle-aged kids, and potentially older individuals very differently. Now, if you have somebody with a disability or an addiction, you're never going to give them the right to be in control. You can't, right? You want to hurt somebody with an addiction, give them money. You want to hurt somebody with a spendthrift problem, give them money. So we're never going to do that. But you may end up saying, hey, when my kids are 45, I think they'll be ready. I think they'll be ready to assist. They'll be ready to be a co-trustee. They can't be the sole, because if they're the sole, the creditor has direct access, but they can be a co. And then you can give them rights to fire that co or appoint someone else. So you get a lot of flexibility with allowing people to kind of manage their money or not. When I set up my parents' estate planning, I had it set up that it would be in trust until I reached the age of 44 years old. And my sister would be the co-trustee managing it. Well, now I'm over that age. So if my father were to pass away, I would be the co-trustee, but I would still have my sister with me. The difference is, now that I've reached the age of 44, if she said no to me for some reason, I could remove her and appoint someone else. But I had to earn that right? I didn't have that right until I was 44. So that's where we get a lot of flexibility with trusts and being able to have it asset protected, but making it unique to your children and who they are and how they are and whether they've earned that right or not.
So Jeff is getting it's always good that Jeff benefits from this, because Jeff is getting really great Christmas gifts from his sister.
Yes. Yes. Yeah. And who do you think's the co-trustee of my sister's money? Right. So it's a benefit to each. And, a lot of people have said to me, well, isn't that fraud, or isn't that, a wink, wink, nod, nod? No, I'm sitting in a fiduciary role as a trustee, right? I'm a trustee. She's a trustee. We're both held as fiduciaries, which is held to a higher standard. And the law always says, we give the benefit of the doubt that the person is going to act in the role that they are in. And they're going to do the right thing because they're the fiduciary. So it's kind of fun and it works. It's really good planning as long as you understand it. And it provides a lot of flexibility for families. And if you have 3 different children, you might have 3 different children. You might have 3 different kids, right? Who act very differently, who one might be responsible, one might be crazy. You could treat them differently. You don't have to treat them the same.
Cool. Okay. I think that pretty well covers it for now. I appreciate your time. Thank you so much.
It's good.
And it's good to know, it's good to see how LLCs and trusts all work together, not only for tax purposes, asset protection, but also being able to leave those properties to the benefit of others that are going to, outlive us.
And future generations. Absolutely. Yeah, I'm a big proponent of not controlling from the grave, but protecting from the grave.
Certainly. And I think this also highlighted the need to do some serious head scratching and thinking about what that's going to look like, so that people say, what happens if, or what happens when? Mm-hmm. I'm not sensing that from a lot of investors. They're about building their portfolio, getting the cash. They're thinking about the here and now, but they're not thinking about their kids. They're not thinking about long term, or what happens, 50, 30, 40 years down the line.
That'll never happen.
You mean my kids won't live now?
or you'll never end up in a nursing home, or you'll never end up in a car accident. I hear it all the time. And, you can't argue, right? You know, when someone says to you, I'll never go to a nursing home, I'll never get in a car accident. That's not logical, but you can't argue with somebody who says that because they truly believe it. You know, that's not the world I live in. That's not the world that I've worked in the last 20 years. So what I tell people is protect yourself, put as many layers as you can between yourself and any potential creditors that may be out there, entities, holding companies, trusts, umbrella policies. Do as much of that as you can, because the more layers you have between you and the creditor, the less likely they're going to try anything.
Jeff, if people have, I'm going to put your contact information on the back end of this, but real quickly, how do people reach out to you or a member of the team to set up they can't set up an appointment with you because they have to go to a class first.
Well, they have the ability to go direct to an attorney, but it does cost to do that. Our mantra is we want you to be educated first and foremost, so that what happened to my family doesn't happen to yours in that hospital room. So we encourage people to go to workshops. If you go to a workshop or watch one, you get a free consultation with a team member. If you refuse, then we will ask for a fee to meet with the team member before, which either way is fine with us, but we certainly believe that the education is well worth it and you won't be disappointed.
So, and we can find those workshops at BellomoAssociates.com, I think.
You
right?
got it. Yep. It's our website. And also, if you want to call the office at 717-845-5390, the team will be able to give you those verbally as well. But the website's probably best. Just that way you can kind of see all the different workshops between York and Lancaster and the different types that we offer on a regular basis.
Great. Looking forward to the next one. All right. Jeff Bellomo with Bellomo and Associates. Thank you so much, sir.
Thank you, Paul. Appreciate it.
Okay.